Okay, a couple days ago, I reported on. Now I'm doing a lot better, but I'm still sick. So grant me some slack here. About the Diddy case, how he's suing Warner Brothers, right? Warner Brothers, right there. Okay. Okay. So the government. This is coming from the U.S. Department of Justice. Okay. So this Department of Justice, writing to the judge, dear Judge Solomon, the government writes to join non-party Warner Brothers Discovery Incorporated motion to squash the defendant's Rule 17C subpoena. The subpoena sees District Number 219 for the reasons set forth in the motive memorandum. My husband's opening and closing the door. Of law. The subpoena exceeds the limit scope of Rule 17. What they're talking about is Diddy in this, he sent this, his lawyers sent, his team of lawyers sent Warner Brothers subpoena wanting diaries, journals, video outtakes from the making of Diddy, or the downfall of Diddy. Now, let's finish. I'll finish. Indeed, the subpoena exclusively seeks impeachment material which is plainly not authorized by Rule 17. See, it's not authorized. You cannot sit there and ask for someone's personal diary and journals and stuff for your criminal case. You cannot do that. Citing decades of cases in this circuit, strengthening the rule that obtaining impeachment material is not a purpose use of the Rule 17. According to the government, joins the Warner Brothers Discovery Incorporated motion and respectfully request the courts squash the subpoena. So why do they want to squash the subpoena? Is because now it's already been ordered. See, this was on April 8th. When this went down, this was April 8th, and it's already ordered. See, Iran, Samarin, United States District Judge, Warner Brothers Discovery Incorporated, filed a motion to squash a subpoena served on it by Defendant Combs. Okay, any response should be filed by April 10th, so they got till today. So ordered. Okay, so, and you just seen what happened yesterday was the U.S. Department of Justice. What happened is they're asking, he wants all this material. Diddy wants all this material. See? The Fall of Diddy. See the TV series? He wants them to give them material on the. We'll go down. I'll show you. Hold on. Request all recordings or interviews with individual A or individual B created in connection with the Discovery series, including all unaired outtakes. So he wants everything, right? All diary entries, journals, narratives, or notes provided by are either individual A or B, individual B, in connection with the documentary series. So he wants their diaries, their journals, and you're not getting it. Okay, you're not getting it. He wants records of any financial payments made to either individual A or B in connection with the documentary series. Okay? And remember I put this up. The subpoena should be squashed because it exceeds the limited scope of the Rule 17C. He cannot go in and ask for all this personal information in this court document, okay, against Warner Brothers. That he does not have, it does, let's just go look up, okay. He doesn't have the authorization. He's not going to get the authorization, okay? computer talk, I don't care. Subpoenas, the unfair limits of a defendant's ability to prepare a defense, part 1. Okay? So, do you hear this? The unfair limits of a defendant's ability to prepare a defense. So he's not being lawful in asking for this material from the witnesses that were on this program and suing Warner Brothers, the Downfall of Diddy documentary series. So as you can see, the subpoenas is unfair limits on a defendant's ability to prepare a defense. You can't do this.
During a criminal investigation, the government has nearly unlimited powers to gather evidence against a defendant. It can use grand jury subpoenas usually with no court oversight unless the recipient objects for documents or to compel testimony of any witness. It can use its agents to interview witnesses voluntarily, knowing that most people will feel obligated to talk to a federal agent who asks to speak to them. The government issues extremely broad grand jury subpoenas. It doesn't expect that everything that will be produced in response will be admissible, or even necessarily used in the case. The purpose is to investigate what happened. You would think that a defendant would have the same power to gather evidence and investigate defenses to criminal charges after an indictment. You'd be dead wrong.
See? So, as you can see, so let's look at the Rule 17.
Rule 17, C, the language. Let's start by looking at the rule itself. Here's what it says. C. Producing documents and objects. 1. In general, a subpoena may order the witness to produce any books, papers, documents, data, or other objects the subpoena designates. The court may direct the witness to produce the designated items in court before trial or before they are to be offered in evidence. When the items arrive, the court may permit the parties and their attorneys to inspect all or part of them. 2. Quashing or modifying the subpoena. On motion made promptly, the court may quash or modify the subpoena if compliance would be unreasonable or oppressive. 3. Subpoena for personal or confidential information about a victim. After a complaint, indictment, or information is filed, a subpoena requiring the production of personal or confidential information about a victim may be served on a third party only by court order. Before entering the order and unless there are exceptional circumstances, the court must require giving notice to the victim so that the victim can move to quash or modify the subpoena or otherwise object.
And now you see why they moved to squash. And it's been ordered, right? And here is what did I just tell you today? This is the U.S. government. This is what? The U.S. Department of Justice. And they're asking for them to squash it. Because it goes against the victim, okay? When Diddy is sitting there asking them for all this personal information, now the court has the right to have it. Yes, and the victim, the defendant also, but not to this extent what Diddy plans on doing with it, right? Who knows what he's planning on doing with it? We've seen his, how he acts, okay? And the court sees what he's been doing. He's trying to obstruct the court, and that's why they're asking to not let him. Look, you can't sit there and give him documents, the journals, the videos, and all this. He has the right to ask for it, but they also have the right for the motion to squash. And why? Because you have to protect the victims here. Okay?